I would get off of work and I would come back and it'd still be a party going on. I would try to go to sleep. It would still be yelling, screaming, fighting, arguing, good times, bad times, yet I'm trying to sleep.
This is the plaintiff, Derek Robinson. He says the defendant was his good friend, but the guy now owes him money for some coats he lent him that he can't get back from the guy. These are very expensive jackets that cost him $1,000, and that's exactly what he's suing for today. This is the defendant, Ray Gauss. He says he has no idea what this guy's talking about because he doesn't have his jackets, and if anyone's owed money today, it certainly isn't the plaintiff. He's accused of a coat caper. The defendant has filed a countersuit for $480 for unpaid rent.
All parties, please raise your right hands.
What you are about to witness is real. The participants are not actors. They are actual litigants with a case pending in civil court. Both parties have agreed to drop their claims and have their cases settled here before Judge Marilyn Milian in our forum, the People's Court.
People's Court is now in session. The Honorable Judge Marilyn Milian is now presiding. Litigants have been sworn, Your Honor.
Thank you, Douglas.
You're welcome.
Mr. Robinson, you used to live in a home with Mr. Gauss, correct, Mr. Robinson?
Yes, ma'am.
How long did you live there?
Approximately about 18 months.
Okay, and what happened?
What happened was, with the living situation, I was working at the time. I'm working now, but at the time that I was working, I was definitely contributing to the household, and I would work 12-hour shifts. I would get off of work and I would come back and it'd still be a party going on. I would try to go to sleep. It would still be yelling, screaming, fighting, arguing, good times, bad times, yet I'm trying to sleep after working 12-hour shifts.
How much were you paying in rent?
The deal and the agreement was wherever I can help, that's where I would help. RG&E, which is gas and electric, I definitely paid gas and electric bills in full. I definitely contributed to food in the household. There have been meals that I specifically, because Ray's a good cook, I'll give that to him. And there have definitely been times where I say, I have a taste for this. And he'll say, you go get the food, I'll cook it. And no doubt, he would cook it. And when I get out of work, guess what? No food. No food for me, no food for my children.
Okay, but hold on.
I just got fed up with it.
Were you paying rent or you weren't paying rent?
I was paying gas and electric.
That's it?
Yeah, but to be a 4-bedroom house with company in and out all the time, yes, $300, $400 a month.
How much?
Gas and electric.
That's what I was going to ask. So $300 or $400 a month of gas and electric. All right. So now.
Correct.
You decided after 18 months that you were going to move out. When you moved out, you didn't tell the defendant anything. You just moved, correct?
Not correct. Him and we had skirmishes, we had arguments, we had decisions being made between him and where I'm like, I can't deal with this. It wasn't a sudden thing. It wasn't a microwavable thing. It was something that took time to build. There were straws being built because I'm like, if I'm buying food for my children and I come back and the food's gone, I can't help it that it's gone. That was always his answer. And this happened continuously, consecutively. This happened all the time. And I'm like, Ray, I can't deal with this. Goodbye. You can always leave.
What happened all the time? That Ray was eating your food or that other people were eating your food?
No, other people were. This was not a doing of Ray. Ray has a good heart. He does. And Ray does not know when to say no to other people. So other people would come in and they would literally just open up the refrigerator and do as they please. Okay. I can quote him when he would
Robinson,
say, I can't stop them.
Take it down a notch. I know you're excited, but take it down a notch because you're kind of yelling, and I'm trying to understand how you left. I've read the text, and it sounds like you left in the middle of the night without telling him. Like, it's not like you said, hey, my last day is 30 days from now or anything like that. You just left in the middle of the night without telling him. Okay. So now you are suing because according to you, when you left 2 jackets at the house. They're jackets. Why didn't you take them with you? It's not like they weigh a lot or anything. Why didn't you take them?
I didn't take them because I didn't want my jackets to be torn. I didn't want them to, because when I moved in a pickup truck. I didn't have a U-Haul, and the Miami Dolphins jacket, that was brand spanking new. I didn't want it to get torn. I didn't want it to get ripped, and the other jacket is suede. I didn't want that to get damaged neither. I packed that truck.
Why didn't you just put them on your lap? You don't have to put them in the bed of the truck. You could put them on your lap and they wouldn't get damaged.
I understand your sentiments.
Did you forget
but at that
them?
time?
Nope. You deliberately left them there instead of just putting them on your lap. Got it. Mr. Gauze, tell me what happened between you two.
Well, part of what he's saying is true. I do have a big family. They come in and out, and I try to preach to all of them. Before you go in and put your hands on anything, ask, because it may not belong to me. So I may be at work, and sometimes I'd come in, and this is gone. I hear it. I'm at work. I get a phone call. Yo, did you tell so-and-so? Can you talk to so-and-so? But I'm at work. So, I'm not here when everything transpires.
Okay. Did he leave some jackets at the house?
Actually, I have no idea. I didn't know he left until I came in from work. I actually came in to blow the driveway. So I came in, I cut the light on at the top of the stairs. The light didn't come on, and I turned and I looked at the stove. The stove was off. And I said, wow, the RG&E is off, and he's gone. And it's dark, so I'm ticked. I go back, sit in the truck with my cousin. As I'm explaining it to him, Dirk walks up the driveway. And I'm ticked, and I told him, anything in that house, you will not set foot back in that house. I don't give a damn what you have left. But at that point in time, I didn't see the jackets. I didn't realize that he had left already. But like you said,
okay,
I'm not the only one.
my question to you is, have you since seen the jackets? Do you have any idea where the jackets are? No,
I don't. Like I said, I wasn't the only one that had access to the house. There were 4 of us living here. So, I'm at work during the day. So I don't know what transpires when I'm not here.
When you make a statement like, I told him anything else you left in there you're not getting, that's a little concerning to me in a case where he is suing you for keeping 2 things.
It is, but at that point in time, I wasn't thinking, I didn't know what was in the house because it was dark. I hadn't only walked in the house a hot 30 seconds and turned around and came back out.
You have a counterclaim against him for $480, Mr. Gauze, for back rent for September and October and part of November. When did he move out?
This had to be...
Is your testimony that he's supposed to pay $200 a month?
$200 a month, and that will go towards RG&E and the cable bill. And everybody purchased their own food, their own personal hygiene, their own laundry detergent. And
so was he always supposed to pay $200, or was he just supposed to pay the electric bill?
He was supposed to pay $200, but what had happened was the RG&E had gotten turned off, and it was put in his name.
How much was he paying a month? Was it different every month?
No, it wasn't different every month. Originally, it was $200, but when he put the RG&E in his name, that's when I wasn't charging him the $200 for rent.
And then he just started paying it directly.
Right.
That's not a good way to do this.
It's not, but...
It's not a good way to do this. Mr. Robinson, did you ever you never contacted the police to say, he's got my jackets, I need an escort to go in there and get them, or anything like that, did you?
No, I did not, because I was assuming that after, cooler heads prevail. So I was assuming that after he had time to cool down, that he would say, you know what? Because I even asked him, I've asked his family members, where I said, can he just leave them on the porch? And he doesn't have to see me. I don't have to see him. I can just come and pick them up
I'll
off of the porch.
tell you why. In case you don't understand why, you're awfully angry for a guy who did him dirty. You left in the middle of the night and you canceled the lights, so now he has no electricity and no notice that you're doing it. I understand why you canceled the lights, because they were in your name. But that's all the more reason to give somebody some warning about what you're doing, especially in a situation where you have housing, you know, for $200 a month. You know, I mean, it doesn't make any sense. You're super angry, and I'm kind of not getting why. When you're talking about what a great heart he has, then why would you do him like that? Why wouldn't you just say to him, listen, next month is my last month. This isn't working for me. People steal my food, and I don't like the party. Whatever. But why did you have to leave the way you left? Explain to me how it is that you want the cost of 2 jackets and then the replacement cost also of 2 jackets, as though you should be paid for 4 jackets. In what planet would that make any sense? That's one. And 2, I need to understand, because I see the proof you brought that one of the jackets is worth $95, why you're suing them for $250 for that jacket.
What I showed you was someone attempting to sell the jacket that, I'm not saying that particular jacket is mine, but if someone's selling it used for $95 and I contacted
I know.
and they no longer make that jacket anymore. So
And then
I couldn't come
I
up
don't
with,
see any proof of the value of the Miami Dolphins jacket.
when I contacted NFLshop.com, I contacted them. I asked them, can they email me the receipt for my jacket? I've never received the email, and I've never received the receipt from NFLshop.com.
Okay.
Never.
Yeah, we're in trial right now. Now's when the trial. So what happens when someone doesn't bring proof to court on the value of something is that you're stuck with whatever I say the value is. Let me ask you a question on your counterclaim. According to you, he owes back rent, but Mr. Gauze, you've already explained to me that he was paying the electric bill. When did you leave? November what, Mr. Robinson?
Yes, ma'am. I left there, we can say November the 10th. Around that.
Okay.
November the 10th.
Are you suggesting that the electric bill wasn't paid for September and October, Mr. Gauze?
Yes.
Did you pay the electric bill for September and October, Mr. Robinson?
Oh no, yes, he paid. He did pay that.
Okay.
He did pay that.
All right.
But
Well, then why would he owe you back rent if he paid that?
Because it was still off. I had to go 2 weeks without electricity before I could get someone out and get assistance to get it turned back on.
Why? All you have to do is place a phone call to get it turned back on, and you probably had to put a deposit or something, but so what?
Right.
You didn't need 2 weeks.
Down.
That's silly. None of that makes sense.
No,
You're not owed any rent. And I got to tell you, when you make the statement that you saw him out there and you said, whatever you've left here, you're not getting back, and then that's precisely what ends up happening. But Mr. Robinson, you are really unimpressive when you deliberately leave 2 jackets behind in a place where you know that someone's going to be terribly hurt that you're doing it the way you're doing it, like leaving him without electricity. All right? So what you're going to get is a depreciated value, and you're not going to get it 4 times. You're going to get the depreciated value of the jackets that I do believe are over there. I am ordering the defendant to pay you $200. That's my verdict.
Thank you.
Well, it's obvious the plaintiff was not too happy with that verdict. He's going to get $200 now from Mr. Gross. Mr. Gross, you didn't get anything on your countersuit, $480, but you got to give Mr. Robinson $200. How you feel about that?
It is what it is.
It is what it is. You don't know where the jackets are. They're not there. You have any idea who took them or where they went?
No, and I wouldn't understand why he would leave them. If you're going to do a person dirty like that, make sure you take all your belongings.
Yeah, well, that's good advice. Good advice. All right, sir, that's the judge's verdict. Mr. Robinson, you're only going to get $200, and the judge still can't understand why you didn't take those coats with you, you know? I know you're not happy, are you?
Listen, what it is hindsight is 20/20. I didn't take my jackets because I just didn't want to damage them. I was thinking, like, get my stuff and go. I just wanted to get my stuff and go. You know what? $200 is better than nothing, because I already know. I've seen the coat on sale online. Somebody by the name of John Doe is selling the same coat, same size in our area that we live in. So, come on. But I appreciate it. And I understand the logic of the judge, and I'm appreciated.
All right, good enough. All right, that'll wrap it up for this case. Let's see what the judges have to say now.
Typically, when you file a lawsuit because you've lost something, it's been damaged or disappeared in the care of someone else who's obligated to take care of it, you don't get the full value of the item.
No, it's a used item. You get the value of the item at the time of the loss.
Right.
Which is
it's a shame. You got to take
jacket.
your lumps, but that's how it is.
Yeah.
You get the used item or you get the depreciated value, which is exactly what you found here. Interesting relationship between these guys. And in that household, it sounded so unstructured. And as a judge, when things go wrong from an unstructured environment, it's like the difference between if you have a fight and there's two guys and everybody's watching and they're going by the Marquis of Queensberry rules. You know, you could see who strikes a blow, who falls down, everything else. If it's a free-for-all and there's chairs flying and everybody's every place and you don't know what, you can't reconstruct, you can't score the fight, you don't know what the hell's going on.
And you're the judge afterwards.
Messier. And that's what that
so
house
his
was
rent
like.
was different every day.
Right.
Every month his rent would be different. It would be whatever the electric was.
Yeah, so his rent was high in the wintertime and maybe low in the summer. Who knows?
Right. It's a terrible way to do it.
Gloria wants to know this. Hey, Harvey, my father-in-law caught COVID from a worker who came to work infected. What can we do? She shouldn't have come to work. Well, here's the thing. This really has been untested in a lot of courts, but based on what I've seen in the law over time, I think if somebody knows they have COVID and then doesn't take precautions and gets next to somebody, exposes them to the virus, and that person gets it and they're irresponsible and they're not following guidelines, that, my friend, I think is negligence, and I think you well might have a case. And that will do it for this case. Litigants for the next case inside the courtroom.
This is the plaintiff, Robert. He says he hired the defendant to do some stonework in his Zen meditation garden, and the guy got the wrong color stones. The defendant refuses to correct his mistake, and he's here suing him for the $615.56 he's owed. This is the defendant, Christopher Jensen. He says he just delivered the 8,000 pounds of stone. The plaintiff ordered the color. He has no ill will against the plaintiff, but he didn't make the mistake. The plaintiff did. He's accused of being heavy-handed. The defendant has filed a countersuit for $250 for delivering the stone.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case on the docket. The plaintiff hired the defendant to do some stonework in his Zen meditation garden and says that the guy botched the job big time. But the defendant says that all he was hired to do was deliver 8,000 pounds of rock. And that's exactly what he did. It's the case of everybody must get
Litigants
stoned.
have been sworn, Your Honor.
Thank you, Douglas.
You're welcome.
Okay, Mr. Robert, you're suing Mr. Jensen for money that you're out for 2 pallets of stone, which you say are the wrong ones, and it's his fault. Tell me about your project.
I had a 24-foot swimming pool removed from my backyard last spring. The project would be a round meditation garden with a wall, about approximately a 1-foot wall around it. There was a wall built about half the height of what I wanted. Then Mr. Jensen came in. He did a great job bringing in stones, crushed rock, building the garden space inside of it. When that was completed, we were on good terms. I paid him the full amount requested, and he said he could help me. He could complete the wall that had been begun around the garden.
Why was the wall half done?
I had run out of stone. The mason I had ran out of stone.
Okay, and you didn't have the funds to buy more stone?
Well, no, I couldn't get matching stone. It was difficult to get matching stone.
Oh, okay.
At that time, I was only using one supplier that I knew of, and they didn't have the stone in stock. There it is.
Okay, yeah. All right, so go on.
Mr. Jensen said that he could complete the wall for me. We negotiated a price. It all sounded good. He asked me to call in the order to a landscape supply yard in his town. I called in the order. I ordered Pennsylvania bluestone. I understand that different yards have different names, but I was looking for, as you see in the picture, a bluestone. On a Tuesday morning, I don't have the exact date, June 24th, whatever, I was at work Mr. Jensen called me. He said, Bob, the stone they have here isn't the stone that we need for your wall. This isn't right. And I said, well, you know, you're there on site. You've been to my yard. You've seen the stone. You worked over it, around it for 3 days. You know exactly what I'm looking for. So pick out the stone that we need.
Mr. Jensen, what was wrong with the stone?
Ma'am, most of what the gentleman said is highly accurate, except for the fact that, you know, he had called me and said, I picked out the stone. Can you go get it? And I said, I'd be happy to. And I went down and I got it. It was tagged. He paid for it with the credit card. You know, he did the transaction.
But what was wrong? Okay, hold on one second. You're not answering my question. He had just said that you called him from there and said, wait, this is the wrong stone. What was wrong with the stone? What did you call him about? What did you say? What was wrong with the stone?
I don't believe I did. I called him in regards to picking it up and paying for it, but he had tagged it out.
Okay, so you had nothing to do with selecting the stone?
No, ma'am.
All right, Mr. Robert, according to you, he says the one you picked is wrong, let me pick another. He denies that. Is there any proof of that? Do you have texts or emails or any proof?
That was through phone calls, so I don't have proof of that. We were back.
So he brings the stones to your house, and then what happens?
I came home, I looked, I said, oh my God, these stones are totally wrong. I immediately called him and texted him and said, you know, these stones absolutely don't work. I don't know how he didn't see that. He delivered the stones, as you see in one picture, like within 1 foot of where the wall is. I don't see how he could have not seen that and why he continued to unload the stones on my yard when he could see that they didn't match. Those stones are called colonial gray wall stone. I wouldn't have ordered a gray wall stone.
Yes, I understand, but according to him, you hired him to work at $250 a day, and he spent a day going over there, picking up the stones and bringing them to you, right? Now, the stones are wrong, and if they completed your order with the wrong stones, that's between you and the people you bought the stones from. You know, you're going to have to prove what you're saying, which is that a guy who's hired by you, after you pick out the stones, and you say what you want, and you pay with your credit card, and it's your order, he turns around, changes your whole order, so the fact that it's the wrong color's on him. But now what I'm trying to understand is, I see from your text that there's a way to return the stones. You can return them within 30 days. Is that correct?
60 days.
60 days? Why didn't you just return them?
Well, myself, 2 reasons. One being that I don't have a truck big enough to return the stones. The other, because they wanted the stones returned on the pallets. We're talking 1.5 tons of stones. The other reason being that he still has a 0.5 ton of my stones, so I didn't have all the stones to return.
Right, but you could have, okay, that would have been much easier than what ends up happening. What ends up happening is what? You don't like the stones, what do?
I asked him to return the stones.
And what did he say?
Well, you'll see in the text that he asked for $250 to return the stones.
He says, dropped off a pallet and a half. We'll meet with you tomorrow. And then I guess you guys must have communicated otherwise because you say $250 to get the wrong stones delivered. And then you say the company would have delivered them for $65. I don't know why you didn't have the company deliver them. I remember agreeing to $1,200 to build the wall. I don't remember agreeing to a delivery fee. But now you've got me over a barrel, right? Where are you saying you changed the color and this new color doesn't work? Where's all that? Why can't you just call the company and tell them to come pick them up if they only charge $65 for a trip? See, you're suing him for $615.56. You want him to pay for the cost of the stones because according to you, the time has run out to return the stones, right?
Right.
But what efforts did you make to get the stones returned? Hiring somebody else if he didn't show up? I see that there was an agreement by you with him in August to pick up the stones and return them. What happened with that, Mr. Jensen?
We came to an agreement with that, Judge. I was going to go down and pick up the stones. And Judge, by the way, it was $500 a day, and I worked half a day delivering the stones. It came out to $250, so that is correct. My backhoe only picks up like 2,200 pounds. There was 2 pallets, so I had to unload 1 pallet in my driveway, which is still there, And the gentleman's welcome to the stone. I'm not withholding the stone, okay? So I had to break down.
Well, you haven't delivered it. Stop. You haven't delivered it, have you?
No, ma'am. I delivered half of. There were 2 pallets.
No, I understand, but you need to stop. You need to return what you have, because if your position in this case is I don't owe you anything, you owe me $250 for my labor, then I expect that those stones at your home will be delivered to him. They should have already been delivered to him. If your position is these are your stones, I have nothing to do with it, pay me for my troubles, then why haven't you delivered the stones already to his house so that he can return them?
That would have been another day. Yes, ma'am. That would have been another day's work. He didn't pay me, okay? And I couldn't carry legally the weight of 2 pallets of stone with the backhoe to dispense the stone in his backyard.
That's a you problem. You can't have half the guy's supplies and then say, but I don't owe you anything for supplies. In a case where you're being sued for the cost of the supplies. You see that, right? That at some point you needed to go ahead and go and give him back all his stuff, and then you could say, hey, you owe me $500 or whatever, but you can't keep his supplies in a case where you're being sued for the cost of the supplies and then say, I don't owe you anything for supplies, but yeah, I never finished delivering the stones.
I do respect that, ma'am. Yes, ma'am.
I see in the text where you agree to go ahead and go with him, get the stones returned, and pick out the right stones. What happened with that?
I wanted to be paid the $350, the $200 for delivering the stone, and then I think I told him $100. I was trying to be reasonable, and I would pick up the stone for $100. You know, I was wanting to work with the gentleman, but he said, I'm not paying you anything, and I'm like, well, okay, but by the way, it's his stone. If he wanted to have JJ come pick it up for the $65 and return it, they would have done that. I wouldn't have had.
No, he can't come get it. No, you're asking to. No, because you, at best, you got hired to deliver the stones, and that's what your counterclaim is for. And yet you kept the supplies.
Yes, ma'am. But I never told him that he couldn't.
And you made a plan with him that for $100 you would go with him, return it, and you had a date and everything. Everything was set. And why didn't that happen? What did he tell you, Mr. Robert, for why that didn't happen?
There were several dates sent when he was supposed to come. He told me he had low blood sugar one day. He told me he had a flat tire one day. He told me he had to respond to a mold emergency on Cape Cod one day. Some other days he just didn't show up. I spent the whole weekend home once waiting for him, and he never showed up an entire weekend.
How much was the agreed upon price per day for him to work, Mr. Robert?
That's a point I'd like to make. The agreed upon price was a total price for the job. It wasn't a per day cost. There was no price particularly for delivery. It was an entire estimate for the entire job, which I believe was $1,200.
Yeah, what evidence do you have that there was an agreement to pay you $500 a day? Because I see in the text the opposite of that, an agreement to have the wall built for a set price, the $1,200. That's what your text says.
Welcome back to the People's Court. So who's stonewalling here? Let's find out, because Judge Millian is about to gavel down this case. We're going back into the courtroom.
There was an agreed price for the $1,200 for the wall, okay? But anytime the tractor came into play with the backhoe, when I did all the previous work and when I was delivering the stone, when I had to bring the backhoe down there, I told him $250 for half a day and $500 for the full day with the backhoe involved.
With the backhoe involved, and the backhoe was involved in picking up the stones. How?
You're missing the point, ma'am, and I'm trying to explain it to you.
No, you're missing the point. You are absolutely missing the point, and let me explain to you how you're missing the point.
Okay.
All right? For you to get your counterclaim of $250, which you have always said is because of half a day's work, okay? You've never mentioned the backhoe being involved. You need to be able to prove to me that he agreed to pay you $250 for the one thing that you did, which is deliver the stones. Over and over in your answer to the complaint, you say, I delivered the stones. I delivered the stones. That's all that happened. Yes, he's not proving that you changed the color of the stones, but You have a counterclaim for $250 saying that you're owed that. You need to prove it. Just like I tell him to prove it, you prove it. And the answer to that is you cannot, because you say one thing in your answer to the complaint and in your text, which is, I don't work for free, you owe me that for working half a day. And now you're telling me for the first time, oh, that's because my backhoe came into play. So that's why he owes me that, which you also don't have in writing. What you were saying is not supported by the only evidence I have between you guys, which are the texts. And in the text, you say the whole job is $1,200. You don't say that's part of the job and then it'll cost you $500 every day that my backhoe's involved. There's none of that. So that's not truthful. And when you, Mr. Robert, tell me that he changed the color of the order, you have no proof of that.
Could I speak to that? I think I might.
Go ahead.
I have a text that I sent him. I said, the 2 pallets of PA, meaning Pennsylvania quarry mix, are ordered.
I don't care. I'm sorry. Does that show that he changed the color, yes or no?
Well, it does, because I ordered PA quarry mix, and he came back with a tan, colonial gray wall stone.
Okay, I see what you're saying. So hold still. The 2 pallets of Pennsylvania quarry mix are ordered. How does that prove that he's the one who told you to order that? And what was that other document you wanted to show me?
The reason I ordered it is because this is what the other supplier called it, was PA quarry mix. PA quarry
right, but
blend.
that doesn't say, stop. That doesn't prove that he's the one who decided to call it that. And, you know, shame on you if you're not going down to the store to see what color you're ordering. That's on you. If you can't prove he changed the color, then that's not on him. Now, Mr. Robert, explain to me why it is that you have allowed the date for the return to pass without returning the stones that you have.
Well, I can tell 2 reasons. One, you've heard from Chris, it takes a lot of equipment to move those stones. And secondly,
right, no, but I'm not talking about you yourself doing it. I'm talking about you calling the store and asking them to come pick it up.
I don't think they would have. I mean, you're right, I didn't ask.
What, says who? You say that in your text yourself. When you're outraged that he's trying to charge you $250 for delivering them, you say that they would have delivered it for $65.
They would have delivered. They delivered. I don't believe.
Oh,
I don't have.
You don't know because you never bothered. You just let there and you just sat there and let the time expire. Okay, well, that's on you. All right. So you've got 1 pallet. He has another.
Could we also address the fact that he made a purchase on my credit card that I didn't authorize?
He bought knee pads.
Yeah.
Go ahead, talk to me about that.
Well, there it is. I mean, when he sent me a copy of the receipt, I texted him. I said, "What's up with the $45 for knee pads?" He has never, to this day, answered that question to me.
I don't know. If he needs them, he needs to buy them himself. Why did you buy knee pads on this guy's nickel?
It was just safety equipment to do the job. If that's the case, I'll pay for the knee pads, Judge. I think I actually left them in his garage, but if that's not the case.
Are the pads in your house, Mr. Robert, or no?
No. My house was closed. I never saw him that day. I haven't seen him since he bought those pads. He wouldn't have had access to my house that day. I don't know why he would have left a brand new pair of knee pads in my yard. I haven't seen them.
As far as I'm concerned, the defendant has complicated this further by keeping half of the supplies. So when the plaintiff sues the defendant for supplies that he is arguing the defendant picked out incorrectly, I am not able to determine that he picked it out incorrectly versus you picked it out incorrectly. However, he has half of the supplies. If we calculate the figures for how much each pallet costs, each pallet is $290.71. I believe that you, Mr. Robert, had an obligation to mitigate your own damages and attempt to have some kind of return on the wrong color. If you didn't, you didn't. That doesn't mean he has to pay for it. But I do believe that he owes you $324.85 for the knee pads and the pallets that he kept at his place. Now, the only thing he's done of service to you is bring you the stones that he did bring you. And then I have to decide what you should pay him for doing that service, because there is a cost to doing that service, time and sweat and trouble. You, Mr. Jensen, are unable to prove to me that what you should have been paid for it, and you, Mr. Robert, are unable to prove to me that you weren't supposed to pay anything for it. I understand that there was a price for a job, but the job didn't happen. So now I've got to figure out what the work that did happen is worth. And there's only one work that happened, which is the delivery of stones that I don't believe you've proven are a wrong color thanks to him. So I'm going to, from the money I say he owes you for the stones and the knee pads, deduct $100 for his delivery. And I am going to order him to pay you $224.85, which at the same time takes care of his counterclaim. There's no proof you owe him $250, so the net judgment between you two is $224.85. Verdict for the plaintiff. Good luck, folks.
Thank you.
So I'm not sure either party will be happy with the outcome. Mr. Jensen has to give a little over $200 back to Mr. Robert. Let's talk to Mr. Jensen first. Yet, would you explain to me why you still have, one pallet at your house?
My machine is only so big, but it's small enough to get in his backyard. Where the judge didn't understand is $65 as they come and drop it off at the curb. They're not going to put it on smaller pallets and bring it in the backyard with the backhoe.
That's an interesting point. They would have only dropped it at the curb. Well, that's interesting for $65. Okay, Mr. Robert, Robert, I'm sure you're not too thrilled, but what are you thinking about the judge's decision?
Yes, he keeps saying that J&J would have left the stones on the curb, but they have a Bobcat with pneumatic tires, and they put them exactly on my yard, exactly where I wanted them.
All right.
That's how it works.
Bottom line question is, you never got your Zen garden done yet. Hadn't been done yet, has it? Or has it?
No. I still have money tied up in those rocks.
Well, you get it next summer, hopefully. Okay?
Yeah.
All
okay.
Right. Well, good luck to you. Thank you very much. All right. Kind of an involved case here. Let's see what the judges have to say about it.
Sometimes things, when you're doing work around your house, remodeling projects and that, certain things are kind of non-delegable. You're not going to turn them over to somebody else. I know you in a million years would never let somebody else pick out tile, stone, brick, anything to match something that you've already started. Am I right?
Seriously, just like a 20-minute ride to the quarry. You couldn't do that to just figure out, to pick the exact thing that you wanted.
You can't delegate that.
You can't delegate that stuff.
Or it's just not going to get done right.
Especially something so heavy and complicated to bring to you,
I have to tell you, you found kind of a middle ground here, and you found a judgment partially in favor of the plaintiff. I found that the defendant's testimony was suspect to me. When it comes time to try to return the stone and try to make things right effectively, all of a sudden he's not showing up. He's giving excuses. He's sick this day. He's got a flat tire. He's got a mold emergency in Hyannis or wherever it is. And I think I would have faded that heat onto him and maybe made a finding that the plaintiff should have recovered the full $615.
Interesting.
But you found it was a smaller number.
I just felt like the plaintiff had, the wherewithal to pick up a phone and call J&J and get them to pick it up for $65, he says. So
or mitigate his damage.
But the truth of the matter is that what swung it for me was just the fact that it got messy thanks to him, the defendant, because he kept a pallet. So how is the plaintiff going to mitigate his damages on that pallet? It's somewhere else. Oh, come pick it up. Yeah, really? That's not how that worked.
He's got hostages.
Yeah, he's got hostages.
In the form of those stones in his own driveway.
Right.
So Xavier wants to know this. Hey, Harvey, I'm 11 years old and watch the People's Court daily. Thank you, Xavier. Why aren't public places taking action against people not wearing masks? If more people were held accountable, then the cases would go down. Man, I couldn't agree with you more. Here's the problem. A lot of states don't have actual penalties if you don't. And the other problem is law enforcement doesn't have the manpower to stop people, arrest them, cite them every time they see somebody without a mask. But I'm with you, my friend, because if people don't wear masks, we're never going to get over this horrible virus. We'll see you next time.